Canada's charter extends equality rights to groups, protecting against discrimination. Groups struggled for their rights prior to 1982. In the years that followed, Canada witnessed dramatic social change for women, minorities, Native groups, and the disabled.
Well, I remember actually in 1982 when the charter was brought in, there were a whole bunch of discussions about how we might exempt some people from the rights under the charter. And one of the groups that was under consideration for exemption was women. And at the time, the minister responsible for the status of women federally, the Honourable Judy Arrelo, worked with legislators across the country, I was one of them, to make sure that we were not included in the notwithstanding clause.
I can recall quite easily 1982 is when I was still in law school, and certainly we didn't have any female police officers, we didn't have any black police officers. Turbans weren't allowed in the police, as if it mattered that you should or should not wear a turban to be a police officer. These things come to mind immediately. So we have seen a sea change since then. Having gone through the change, we take all of these changes for granted. We don't think they are significant, but they are. They are major, major changes.
I'm not so sure that the equality rights have made Canada more tolerable as a multicultural society yet. I think we're on the road to that development, but so far I think it's been more a learning process.
The Charter protects groups of all kinds. It doesn't explicitly define same-sex rights, but it indirectly refers to these rights under the banner of privacy.
The right to equality has been interpreted by the courts to include same-sex rights. And certain other rights, the right to be free from unreasonable search and seizure, the right to fundamental justice, life, liberty, and protection of security of the person, that has been interpreted to have a component of privacy rights. So those rights are there, although they're not spelled out specifically. They've been interpreted by the courts as being protected by the Charter.
Canada is officially bilingual. The Charter guarantees that federal services are available in French and English throughout the country. The two languages have equal status in Parliament and in the courts. In New Brunswick, these rights are also guaranteed for provincial services. Under these language rights, the Charter guarantees Canadians can be educated in either French or English where population permits. Unlike most of the provisions in the Charter, the language rights focus on groups rather than individuals.
French language rights were a very important issue for Prime Minister Trudeau. He wanted very much for French to be a national official language.
Dr. Deanna Dam is Canada's 5th Commissioner of Official Languages. Her federal department ensures French and English language rights are upheld in Canada. The department monitors these rights across Canada, where French is often the minority language, and in Quebec, where the English language is in the minority.
This charter has allowed French to have, let's say, a comfortable place to flourish and promote itself, at the same time recognizing the rights of the English-speaking minority, which is important. And the English-speaking minority is one has access to major institutions linked to that provide services to them in education, health, justice, etc.
It only makes sense to have language rights if you have a sufficient number of people. And indeed, the rights are phrased in that way in the Charter. Minority language education rights are phrased that way. The second practical concern is that these rights require the government to actually do things, actually spend money, build schools, have language programs, etc. And so we have a kind of a tension sometimes between the role of a court, which doesn't ordinarily order the government about how to spend money, and the Charter, which says that those rights are there.
The Charter's language provisions are extensive, and they've turned out to be the most controversial.
Perhaps the best, the most notorious, or the most famous example was in 1988, when the Supreme Court of Canada ruled that the Quebec sign law that required commercial signs to be in French only went too far. The court said you can require French to predominate, but you can't eliminate all English. The government of Quebec at the day couldn't live with that, and so they used the notwithstanding clause to have their signs law prevail. Now, an important feature of the notwithstanding clause is that it has a sunset provision. It only lasts for 5 years. And in 5 years' time, a different government was in power in Quebec, and different situation prevailed, and they didn't reenact the notwithstanding clause.
The Charter recognizes the uniqueness of Canada's language and racial diversity.
The time the Charter was adopted, every jurisdiction in this country had legislation prohibiting racial discrimination in employment, in public accommodations, and in housing. Every jurisdiction had a Human Rights Commission to enforce that legislation. All of that was giving expression to society's increasing and welcome intolerance of intolerance. That's what was happening, and the Charter has given it expression.
Well, I would say that the Charter has significantly impacted on race relations in Canada. You know, the recognition of the diverse culture that Canada has.
We haven't reached perfection, but there is a growing sense of respect for people of other races and colors and so forth. And while prejudice still exists, nonetheless, the law is the teacher. As Martin Luther King said, that law is not only there to regulate, but law is also a teacher.